Okay, so good evening, everyone. This is Shivani again. So today we're going to be discussing on the topic of Section 125 CRPC, which talks about maintenance. All right, so let me share my screen. Is my screen visible to you all?
Yes, it is.
All right. So today we're going to be talking about maintenance under Section 125 of CRPC, right? What are the topics that we're going to be covering? First is what is Section 125. Then we're going to cover the scope, application, and revision under Section 125. Then we are going to see a landmark case, one of the most landmark cases of Section 125. And finally, we're going to see a draft petition of Section 125. That is a petition which is given in front of the Honorable Court. We'll see a draft and how to draft that petition. All right. Now, what is Section 125 of CRPC? Now, a bare reading of the Bare Act provision states that Section 125 is an order for maintenance of wives, children, and parents. If any person having sufficient means neglects or refuses to maintain his wife, unable to maintain herself, or his legitimate or illegitimate minor child, whether married or not, unable to maintain itself, or his legitimate or illegitimate child, not being a married daughter, who has attained an age of majority, where such child is, by reason of any physical or mental abnormality or injury, unable to maintain itself, or his father or mother, unable to maintain himself or herself. A magistrate of the first class may, upon proof of such neglect or refusal, order such person to make a monthly allowance for the maintenance of his wife or such child, father or mother, at monthly rate not exceeding 500 rupees in whole, and such magistrate thinks fit to pay the same to such person as the magistrate from time to time direct, provided that the magistrate may order the father of a minor female child referred to in clause B to make such allowance until she attains her majority, if the magistrate is satisfied that the husband of a minor female child, if married, is not possessed of sufficient means. Now, in this section, the duty to pay maintenance goes to the husband. The husband is the one, or the father of the child is the one who is liable to pay for maintenance. All right. So, for explanation purposes, these are the explanation what a minor means and what a wife includes. Okay, the wife also minor is a person who has not attained the age of majority, and the wife is a person who has been divorced or has obtained divorce from her husband. Such allowance shall be payable from the date of order, and if so ordered, from the date of the application of maintenance. Now, when will the person start paying maintenance? From the date on which the order was issued, the order for maintenance was issued, or on the date which is mentioned in the application, that from so and so date the maintenance is to be paid. If any person ordered fails without sufficient cause to comply with the order, any such magistrate may, for every breach of the order, issue a warrant for levying the amount due in the manner provided for levying fines, and may sentence such person for the whole or any part of each month's allowances remaining unpaid after the execution of the warrant to imprisonment for a term which may extend to 1 month or until the payment is sooner made. So in this subsection 3 states that if the person who is ordered to pay the maintenance, in this case the husband or the father of the child, is fails to pay the maintenance, then in such a case a warrant would be issued, and in such cases fines will be levied for breach of such order, or the person may be liable to imprisonment. He may be compelled to imprisonment for the remaining unpaid amount duration, and the maximum period of time for which the imprisonment can last is 1 month, or until if the payment is made sooner than 1 month, provided that no warrant shall be issued for the recovery of any amount due under this section unless the application be made to the court to levy such amount within a period of 1 year from the date on which it became due. Provided further that if the person offers to maintain his wife on the condition of her living with him and she refuses to live with him, such magistrate may consider any grounds of refusal stated by her and may make an order under this section, notwithstanding such offer, if he is satisfied that there is a just ground for doing so. So basically, this provision, this proviso, it means that if a husband, he has let's say, read the explanation for that. Like if a husband has contracted marriage with another woman, or he keeps a mistress, then it shall be considered a just ground for his wife's refusal to live with him. It will be presumed by the court that if the husband makes a condition that I will pay for maintenance only when the wife is living with me, then in such a case, if the wife refuses to live with the husband, then the court will presume it in the favor of the wife that she had a reasonable ground to not live with her husband. Now, subsection 4 states that no wife will be entitled to receive an allowance from her husband under this section if she is living in adultery, or if, without any sufficient reason, she refuses to live with her husband, or if they are living separately by mutual consent. Yesterday, we talked about the divorce deed and the divorce by mutual consent. Now, in such a case, if the husband and the wife mutually decide that they are not going to be living together, they shall be living separately. In such a case, wife cannot claim for maintenance under this section, that is section 125 of CRPC. If she is involved in adultery, or in certain cases also if she is remarried to another person, in these cases also the wife will not be entitled to receive an allowance from her husband. On proof that any wife in whose favor an order has been made under this section is living in adultery, or that without sufficient reason she refuses to live with her husband, or that they are living separately by mutual consent, the magistrate shall cancel the order. Now, the difference between subsection 4 and subsection 5 is that in subsection 4, this is a condition which was given prior to the order being given. In subsection 5, that already the magistrate has given the order in favor of the wife. And once the magistrate has already given an order in favor of the wife, then in such a case, the magistrate has the right to cancel such an order. Now, we are going to see the scope and application of section 125. Section 125 of the CRPC provides for the maintenance of wife, child, and parents. The court, after the party has invoked section 125 of the court, may order the respondent. In this case, the respondent would be the husband, to maintain the wife who is unable to maintain herself, or the son, the major son who has the liability to maintain his parents, by providing monthly maintenance to the wife or the parents or the child, as the case may be. However, there is one exception to the provision. Now, what is the exception? For the purpose of providing maintenance to the wife, the husband has to have sufficient enough money to support his wife, and after the separation, at the same time, the wife must not be living in adultery or living separately with her husband without any reasons, or like I stated, be married to another person or have divorced by mutual consent. If they are living separately with mutual consent, then the wife will not be allotted to any sort of maintenance. Whenever the judgment is passed in favor of the wife, the court has to make sure that the husband has sufficient means to provide for the maintenance of the wife. Now, this I have not mentioned over here, but this was one of the recent cases, Rajneesh versus Neha in 2020, wherein Justice Indu Malhotra had stated this, that if the husband itself does not have enough means to support for the wife, or if the wife is making exaggerated claims in terms of maintenance, then the husband is not liable to pay for maintenance. Also, apart from section 125, as you all may know, there are many other ways through which a wife can take maintenance from her husband, such as through domestic violence, through the personal laws such as Hindu Marriage Act or Muslim laws. These are the ways through which wife can claim for maintenance. She can file an application in any of the maintenance, but a due diligence has to be searched by the honorable court before passing an order for maintenance under this section to see if any prior maintenance orders were passed or not. All right. In this, that is because we have to see if the husband is really capable of giving a maintenance which is of reasonable amount to the wife. About the scope and application of section 125, I am on the second paragraph right now. All right. So under section 125 of the code, the provision is available for interim maintenance also. You can seek for permanent maintenance as well as interim maintenance under section 125, which means that during the pendency of an application in the court of law, the order may be passed by the magistrate directing the husband to pay monthly allowances to the wife. However, the magistrate has the right to alter the amount of maintenance to be paid if he thinks that there is a change in circumstance of the individual who has been paying or either receiving monthly allowances. This statement was laid down in the case of Vikas versus State of Uttar Pradesh. It also stated that All such applications of maintenance can be filed in any district court where the person is liable to pay or resides, or where the wife resides, or where the person last resided with the wife, or where the mother or with the illegitimate child. The purpose of Section 125 of CRPC is to achieve a social purpose in the society, which also means that all the proceedings under Section 125 are summary in nature and speedy remedies are to be given. Okay. Then comes the scope of revision under Section 125. Section 125 does not have an appeal under it. So, or what happens if the husband is aggrieved by the order passed under Section 125? In this case, the legal option that the husband has is to go for revision proceedings. But it depends on the merits of the case. So, depending upon the merits of the case, the high courts decide whether or not to consider such a revision petition against Section 125. The power of revision is available under Section 397 of CRPC. In one of the cases, which is Ashu Dhiman versus Jyoti Dhiman, which was passed by the Uttarakhand High Court, holding that an order passed by the trial court rejecting or allowing the application for maintenance when the proceedings are pending in the court cannot be considered as an interlocutory order, and the High Court have the right to review the case which has been filed by the other party, which means all the interim applications, interim maintenance, in such a case, it cannot be considered to be a final order against the person against the respondent. Respondent herein would be the husband, and in such a case, the High Courts have the right to review the case filed by the other party, which would be the respondent in the case. Then in another case, the Sunil Kumar Sabharwal versus Neelam Sabharwal, it was held that an order granting the interim maintenance under Section 125 is not an interlocutory order, and therefore the revision of the same cannot be barred under Section 397 Clause 2. When the court has straightaway rejected or allowed the proceedings to be filed in the court of law, then the party should have the right to go for the review by the court of law. It says that the aggrieved party will always have the right to go for a review under the higher court, against which the parties have a remedy. Next is one of the most landmark cases in Section 125 CRPC is Muhammad Ahmad Khan versus Shah Banu Begum, which was in the year 1985. Commonly known as the Shah Bano case, this case is amongst the most landmark judgments of 125, mainly because through this judgment, the court has stated that Section 125 CRPC is applicable to every person, irrespective of the religion. So, what are the brief facts of the case? The appellant in this case, which was Muhammad Ahmad Khan, was married to Shah Banu Begum, who was the respondent, and they had 3 sons and 2 daughters from this marriage. In 1975, when Shah Banu was 62 years old, she was removed from her marital place along with her children. In 1978, she filed an appeal in the presence of Judicial Magistrate of Indore because she stopped receiving the maintenance of rupees 200 per month, which she was earlier receiving. And later on, she also demanded for rupees 500 per month as a maintenance so that she could take care of all her 5 children. Subsequently, the husband then later on gave her irrevocable triple talaq in 1978 and used it as a defense not to pay maintenance. Why it would be used as a defense? Because under Muslim law, there is a period of iddat. After the period of iddat, the husband will not be liable under personal law to provide for maintenance against his wife. So the magistrate in 1979 directed the husband to pay rupees 25 per month as maintenance. Shah Banu again in 1908 made a plea to the High Court in Madhya Pradesh to change the sum to 179 each month, and the High Court increased the price from 25 rupees to 179 rupees per month. The same again was challenged through the special leave petition in this present case, which was Muhammad Ahmad Khan versus Shah Banu Begum in 1985. What was the judgment delivered? This judgment was given by Justice Y.C. Chandrachud, and he stated that this code applies to all.
Ma'am, sorry to interrupt, but in earlier PPT it was written in 1978. The court gave some decision, and in 1908 Shah Banu made the plea. How is it possible?
Okay, no, I think it was 1980. Sorry about that. Right. Thank you so much for pointing it out. Yes, moving on. The Apex Court had stated that this code applies to all the citizens irrespective of their religion. So personal laws will not have any interference under Section 125 of CRPC. The court further stated that Section 125 of CRPC overrides the personal law if there is any conflicts between the two. In the cases where Section 125 CRPC is present and a personal law is present, in such a case, 125 prevails over the personal laws. It makes clear that there is no strife between the provisions of 125 and those of personal laws on the address of the husband's obligation to provide maintenance to a divorced wife who is incapable of maintaining herself. Court in this case duly held that in this present case, the court held that the Muslim husband, the obligation of the Muslim husband towards his divorced wife is restricted to the degree of iddat period, which is iddat period is the time period which I stated after the divorce till the husband is liable to pay for the maintenance. And indeed, so this circumstance does not contemplate the rule of law that is stated in 125 CRPC, and subsequently the obligation of the husband to pay maintenance to the wife is still liable. The payment of meher. Meher is the amount which is paid during the time of marriage. The husband pays the money to the wife during the time of marriage. In such a case, just because husband has paid the time meher to the wife at the time of the marriage, it is not sufficient enough to exempt him from the duty of paying maintenance to the wife. Now, we are going to look at the draft of maintenance under Section 125. This is how the draft of Section 125 is. Application under Section 125 of CRPC for grant of maintenance before the Sessions Court at Ahmedabad, District so-and-so, and criminal application number so-and-so of so-and-so. At first, we write the name of the parties. In this case, I have mentioned one of the parties, their age, their religion, their gender, and their address. In subsequent, applicant number 2 would be the child of the party 1 and the respondent. All right, the applicant and the respondent. In this case, it is the son who is so-and-so person residing at so-and-so place. And again, the respondent would be the husband or the father of the child. Then, after the name of parties comes the subject, which is the application under Section 125 of CRPC for grant of maintenance. The above mentioned applicant humbly submits as under. What do you write over there? Firstly, you write that the complainant number 1 is the legally wedded wife of respondent, while complainant number 2 is the legitimate son of the respondent. Both the complainants are residing within the jurisdiction of this honorable court. You are supposed to say that you fall under the jurisdiction of this court. That the complainant number 1 or the applicant number 1 was married to the respondent according to Hindu rites and ceremonies or whatever religious rites and ceremonies at so-and-so place, and complainant number 2 was born out of their wedlock on so-and-so date. Complainant number 2 is staying with complainant number 1 at present. That complainant number 1 and respondent had stayed together after the marriage and for the last 2 years proceeding. That sometime during the period of June, July, this is the story, this is a draft, where here you mention in this paragraph, like what exactly happened that disturbed so-and-so person and why the maintenance is to be sought. Respondent got disturbed on account of the illegitimate affair, that the complainant got disturbed on the account of the illegitimate affair of the respondent with a girl named so-and-so. So complainant number 1 made best possible efforts to persuade the respondent to desist him from indulging in an affair outside their wedlock. However, the same had no effect on the respondent. Rather, the behavior of the respondent towards complainant number 1 became rude, cruel, oppressive, and finally on so-and-so date, the respondent compelled the complainant number 1 to leave the matrimonial home along with complainant number 2, who is the child of both the complainant number 1 and the respondent. Since then, both the complainant number 1s are staying away from them, right? Now that the complainant number 1 has made repeated attempts to join the respondent in matrimonial home, however, the respondent has refused to take back the complaint and has clearly informed complainant number 1 that he was planning to marry his second person, who was the mistress, that he was having an illegitimate affair with. So, though the same is not permissible under law, as such, even though adultery is now decriminalized, it is still a ground for divorce. Thus, as such, the respondent has deserted the complainants without any reasonable cause. That the respondent is liable to maintain the complainants who have repeatedly requested the respondent to provide them with appropriate maintenance. However, the respondent has not only refused, neglected to maintain the complainants, but has also refused to ever part with or return the articles. Articles of whom? The complaint number 1, whatever she has, the assets towards the dowry and stridan which are lying at respondent's house. That the respondent is a man of status and is working as a so and so person, and he is getting monthly amount of so and so rupees and has sufficient means to maintain himself and the complainants. He has no encumbrances or liabilities except that of the maintenance of the complainants. In such a case, the complaint number 1 has no independent source of livelihood and such is unable to maintain herself. She is staying with her father at Gandhinagar and both the complainants are dependent upon him. Then the complaint number 2 is a minor and she's also staying with he's also staying with complaint number 1. He is studying in so and so place and the monthly expenditure including the school fees, the dresses is so and so, so and so. And apart from this, the complainant has also kept a maid servant to properly look after complainant number 2 and is paying her so and so, so and so, which is being borne out of the father. That the complainants are residing at Delhi. This honorable court is therefore, or Delhi or Ahmedabad, sorry, in this case. This honorable court is therefore competent to entertain this petition. Therefore, the applicant humbly submit that. It is therefore whatever prayer that you want in this such case, such as the maintenance amount of so and so rupees, the maintenance that has to be paid to complainant number 2, the cost of this petitions and the proceedings which are to be awarded to the petitioner, and the honorable court will be pleased to grant any other order and such reliefs as may be deemed fit and proper. And for this so and so, whatever the other affidavits that we need to file. So this was the draft that I shared with you guys regarding maintenance under the section 125 of CRPC. And this was basically what the section had talked about. Any questions?
Ma'am,
Yes, Shipra, you had a question.
ma'am, in case that, ma'am, in the same draft only, if the wife is now residing at some other place, not in Ahmedabad or not in that state, then what will be the jurisdiction of the court?
Then it would be decided upon the jurisdiction where the wife is residing at. Right, so the jurisdiction of the wife and the child, that was the complaint number 2 in such a case, that would be the present jurisdiction where they can file for maintenance.
So I have a question. How the amount of maintenance is to be calculated?
Month of maintenance as in?
The amount that is to be given to the wife, the amount of maintenance, how is that calculated? That what amount of the husband's salary will be awarded to her?
Right. So there are a few factors that are determined before giving the maintenance. The first one would be the income of the husband and how much income the husband has. The second is the dependence of the wife and children in such a case, and whether how qualified the wife is and how qualified the children are. What are the expenditures of the children? What are the other miscellaneous expenditures that the wife has? Then status of the parties in such a case, such as the reasonable needs of the parties, and then the professional qualification of the parties. In such a case, let's say the wife is professionally qualified to start a job on her own, but she has left the job due to taking care of her children or whatever the reason it may be. So in that case, she is not in a position to rejoin her job, right? In that position, the husband would have to it has to be determined by the court how much amount of money is required for so and so miscellaneous expenses that the wife and the children are to be incurred. Yes, Rachit.
Ma'am,
Rachit, your video has paused.
you just said that, ma'am, am I audible?
Yes.
Yeah, ma'am. So you said that one of the criteria for determining the maintenance amount is whether or not the wife has to quit her job to take care of her children. So, ma'am, don't you think in that case, the maternity benefits come into play? I mean, because
Yes. Yeah, you're right on that. As I also stated before, if the wife is in a position to take care of the child, she will not be given the maintenance. All right. It is to be determined basis on case to case basis and upon the factors, various other factors that are to be considered. This is not just one of the factors that will be looked. Overall, as a whole, there will be many other factors which will be looked into it. If the wife is in a position, if she earns well, if she is in a position where she can maintain herself, her child, or any other miscellaneous expenses that she can take, incur, such as the expenses of the maid or any other expenditure that she has to make, then maintenance will not be given. Also, if she is remarried to another person, in that case also she might not be given maintenance amount by this first husband, right?
yeah.
Any other question?
Ma'am,
Yes, Khushbu?
ma'am, can you please explain me this? If the husband and wife are mutually decided to get separated, in this case, the wife will get the remuneration or the part. If she's also earning, then she will get the money or not?
No, she will not get. It is clearly mentioned in the section that if in any case, if the husband and the wife have mutually agreed to divorce, then in such a case, she will not be liable to receive any amount of maintenance. Yesterday, like I explained, there is a mutual divorce deed that was signed by both the parties, right? In that case, also it is to be clearly mentioned that we are divorcing on so and so grounds and mutual agreements, and upon mutual agreements, we have both amicably decided that no longer no amount of maintenance will be given from so and so date, and if maintenance is given, it will not be given from, it will cease to be given from so and so date. All right. In cases of mutual divorce, maintenance is not given.
Okay, ma'am. Thank you.
You're welcome. Any other questions?
Ma'am, can a husband claim maintenance under section 125 of CRPC?
No, husband cannot claim maintenance under section 125 of CRPC because the language of the section clearly implies that it is the husband that has to pay for the wife, his parents, if they're not able to take care of themselves, minor child, and even a major child if they're incapacitated or until the daughter is married off to another person. So under this section, the husband is not liable to receive any sort of maintenance.
But ma'am, what if the wife is financially independent and husband is like a house husband or something?
Even then, there might be other routes of maintenance such as through personal laws, but under this section specifically under section 125 of CRPC, maintenance is not given to the husband. But wife can also, if she is financially independent, then in such a case, the wife will also not be given maintenance. If she can sustain herself and her children, then she will not be given maintenance. Right?
Okay.
Yeah. Yes, Shibra.
Ma'am, I still have a doubt in this thing that yesterday, like we studied the divorce deed. If in that deed it is mutually decided between the parties that this much maintenance the husband will pay for the wife or for their child, then that will be considered as the maintenance, right?
In that case, it would be decided that until so and so period of time, only until so and so period of time, the amount of maintenance would be given. But again, in most cases, when it has been mutually decided or mutually decided to divorce, any sort of alimony, maintenance, assets, everything else gets divided amicably, and there are no liabilities on either side of the party. They have no liabilities against each other in such a case, which is why maintenance is also in most cases not given.
Okay, ma'am. So the maintenance is not liable for the child also.
No.
It wholly depends on the custody of the child.
Yes, only depends on the custody. On in cases of child, in such a case, there will be certain things which are mentioned. Like, for example, it will not be maintenance, but it will be the expenditure that has to be incurred by one of the party. Let's say I have the custody of the child, and person B has decided to provide, is earning more than me, and person B has decided to pay for the expenditure of our children. Then in such a case, it has to be decided amicably who is the one who will be liable to pay for the child, right?
Okay, thank you, ma'am.
Okay. Yes. Who else? Okay, yeah.
Hello, is the meher
Sorry.
or dowry refundable? or will the maintenance be optimized according to maintenance amount will be optimized according to the meher or
No,
dowry?
no, no. Meher is given irrespective of the amount of maintenance to be given. In such a case, the how much ever amount of meher was given in that particular case, like I said in Shahbano's case specifically, or in terms of Muslim personal laws, in that case, the amount of meher given would be irrespective of the amount that is to be given in case of maintenance. So maintenance amount would be calculated post marriage depending upon how much expenditure is yet to be incurred, what are the expenses that are to be given, how reasonable it is, and many other factors. Meher was something which was given during or before the time of the marriage. So it is irrespective of the amount of maintenance to be given to the other party.
So no one can claim the already paid meher or dowry.
No, no, no. He cannot claim.
Thank you.
Hello.
Ma'am,
Good
what is
evening,
the
ma'am.
difference between
Sorry.
Ma'am, what is the difference between alimony and maintenance?
Okay, so alimony is basically an amount which is given as a whole, and maintenance maybe is given in parts, right? Alimony may be as a lump sum amount, while maintenance would be given in terms of monthly amounts. So in this case, we are only learning about maintenance.
Okay, ma'am.
Yes, Ashish, you were saying something.
Yes, ma'am. Good evening, ma'am. Ma'am, Section 124 clause 125 clause 4 says that there would be no maintenance if the parties are living separately mutually. But ma'am, let's take a case like parties are living separately mutually, but they are not divorced, and the wife refused to take maintenance because she was economically capable enough. But later on, she faces some economic crisis, and then she have some requirement of maintenance. So once she have rejected maintenance earlier, later on, can she claim it again?
Yes, so basically, if so, from what I understand, you're saying that because of economic crisis, the wife has taken like a maintenance amount. Like, are you saying from the husband side point of view that if maintenance is to be given even in case of economic crisis, is that what you're trying to imply, or?
Uh, Ma'am, I want to say like a wife initially refused to take maintenance because she was capable enough. She has money, but later
Huh.
on she don't have money. So if she has rejected to take any maintenance, can she later on again ask for maintenance?
Yes, yes, yes. In that case, also she can ask for the claim for file a suit for maintenance. Yes, in that case, she can.
Ma'am,
Yes.
if the husband is not working for some reason, and in this case, wife will charge for the maintenance and she takes divorce, and then what will be the husband will do? How he will pay the maintenance?
So, in such a case, the court will have a look at the financial conditions of the husband, see his property or the assets that are to be given or distributed if neither of the parties are working in such a case, like you stated. And if maintenance is to be given, it would be given from his assets. All right. And in such a case, most of the cases, the wife is able to sustain herself from her properties or her assets. Then, even if the husband is not working and is in an incapacitated situation to provide for maintenance, he will not be liable to pay for maintenance.
Okay, ma'am.
Right. All right, then. Thank you so much.